Welcome to Middle Class Matters, Business News in English from Dr. CMA Allegation. Securities Exchange Board of India, SEBI, departs Subash Chandra, Chairman, and Punit Goenka, MD of ZEE Limited, from holding any directorship in any of its entities or merged or demerged entities. Part number 4 continued. 22. With respect to submission regarding settlement regulations, attention is drawn to Regulation 29(2) of Settlement Regulations. The same reads as follows: Confidentiality of information 29(1) and 29(2). Where an application is rejected or withdrawn, the applicant and the board shall not rely upon or introduced as evidence before any court or tribunal any proposals made or information submitted or representation made by the applicant under these regulations, provided that this regulation shall not apply where the settlement order is revoked or withdrawn under these regulations. Explanation: when any fact is discovered in consequence of information received from a person in pursuance of an application, so much of such information, whether it amounts to an omission or not, as relates distinctly to the fact thereby discovered, may be proved. On a perusal of the aforesaid regulation, it is noted that any proposals or information or representation made by the applicant cannot be introduced as evidence against the applicant before any court or tribunal on examining the submission of the entities in this regard. It is noted that the entities have not submitted specifically what was the information or representation that was made by them, which has been used in the interim order. It is already on record that SEBI had initiated adjudication proceedings in relation to disclosure lapses on part of ZEE Limited, as regards the appropriation of INR 200 crore of ZEE Limited's fixed deposit towards the amount borrowed by the 7 associate entities. It is also on record that during the period 2022-23, SEBI was investigating the matter of Shirpur Gold Refinery Limited. These entities, namely Pan India Infra Projects Private Limited, Living Entertainment Enterprises Private Limited, and Essol Corporate Resources Private Limited, find references in Shirpur Gold Refinery Limited matter. Also figured in the list of 7 associate entities whose loans were adjusted by Yes Bank Limited from the fixed deposit of INR 200 crore of ZEE Limited. Thus, investigation in the matter of ZEE Limited was triggered pursuant to investigation in the Shirpur Gold Refinery Limited matter, coupled with the rejection of settlement application of ZEE Limited and entity number 2. Further, the findings of the interim order are not based on any of the information submitted by ZEE Limited and entity number 2 in their settlement application. Accordingly, the argument of the entities that the interim order relies on the information gathered from the settlement application is devoid of merit. 23. The entities have also contended that they are not a party to the order passed in the matter of Shirpur Gold Refinery Limited. However, SEBI has placed reliance on the said order to foist liability on the entities. The contention of the entities may look attractive at the first read, but on a careful reading of the interim order, it can be seen that the aforesaid contention of the entities has been made without considering the context in which the reference to Shirpur Gold Refinery Limited order has been made in the interim order. The sole promoter of Shirpur Gold Refinery Limited is Jainir Infra Power and Multi Ventures Private Limited, whose majority shareholders are entity number 2, 49.8%, and brother of entity number 2, Mr. Amit Goenka, 49.8%. Thus, there is no doubt that the company, Shirpur Gold Refinery Limited, belongs to the conglomerate SL Group. The allegation in the said order is that funds were siphoned from the company through layered transactions using connected entities for the benefit of the promoters. In the instant matter, a separate and independent prima facie finding has been arrived at in the interim order that funds have been siphoned from ZEE Limited using connected entities through layered transactions for the benefit of promoters of ZEE Limited. Thus, there is a commonality in both the orders, not only in terms of the prima facie scheme employed, but also in the identity of the persons who gained at the expense of the listed companies, and the beneficiary belonged to the same conglomerate, the SL Group. Further, the alleged conduit companies which were allegedly used to obscure the transactions were also common in both the matters, namely Charu Enterprises LLP, Lemonade Capital Advisories LLP, Aditya Multi Trading Private Limited, and Egmart Trading Private Limited. Therefore, the interim order merely referred to Shirpur Gold Refinery Limited order to show a pattern wherein the promoters of the companies that are part of the SL Group have benefited at the expense of the listed companies by siphoning funds from the respective listed companies. The same is nothing but an observation of repetitive behavior of the individuals who are at the helm of the companies belonging to the SL Group. In any case, the prima facie findings which have been arrived at in the interim order are independent of the Shirpur Gold Refinery Limited order and stands on its own set of facts and circumstances. Therefore, to contend that any prejudice has been caused to the entities for the reason that a reference to the order of Shirpur Gold Refinery Limited has been made in the interim order is without merit. 24. Now I proceed to examine the issues as framed in the beginning of this order that are related to factual aspects of the matter. Issuance of LOC 25. The first issue pertains to the issuance of LOC by entity number 1 to Yes Bank Limited. Entity number 1 has submitted that LOC was issued by him in his personal capacity and not on behalf of ZEE Limited, as it is not on the letterhead of ZEE Limited. It is submitted that at the time of issuance of the LOC, he was a non-executive chairman who was not involved in the management of ZEE Limited and was not even an authorized signatory for ZEE Limited's banking financial operations. Therefore, any LOC issued by him could not in any way impute any liability on ZEE Limited. 26. With respect to the submission of entity number 1 that the LOC was issued in his personal capacity, it is noted upon perusal of the said letter that he had signed the said letter dated September 4, 2018 as Chairman SL Group. SL Group is a conglomerate that consists of several companies operating in diverse industries. However, its flagship company is ZEE Limited. And entity number 1 had specifically mentioned the name of ZEE Limited, handwritten it post printing the letter in the said LOC. Insertion of the name of ZEE Limited had certainly lent credence to the LOC, and on cue by the next day, that is September 4th and September 5th, 2018, ZEE Limited had created a fixed deposit of exactly the same amount as mentioned in the LOC, that is INR 200 crore with Yes Bank Limited. Thus, if we look into the following attending circumstances around the creation of the fixed deposit of INR 200 crore on September 4th and 5th, 2018, on a preponderance of a probability basis, it can be held that the LOC was not in the personal capacity of entity number 1, but rather in the capacity of the head of the promoter group having control over ZEE Limited. 26.1. If the LOC was in his personal capacity, there was no need for the entity number 1 to sign it off as chairman of SL Group. The use of word ensure shows that companies belonging to SL Group were accustomed to act under the advice and instructions of entity number 1, which not only empowered him to issue such a letter on their behalf but for the bank to accept such a letter as a valid letter of comfort. Moreover, the word we and not I connoted that he was signing on behalf of the SL Group. 26.2. The name of Z Limited was specifically inserted in the LOC, thereby showing the express intent of entity number 1 to ensure action by Z Limited. His ability to do the same came from the fact that at the relevant point in time, he was the chairman of Z Limited and was regularly attending its board meetings. Therefore, not only was he aware of the functioning of Z Limited, but being the promoter of Z Limited and the fact that he was associated with Z Limited for a significant period of time and the fact that his son was also part of the same promoter group was the MD and CEO of Z Limited, he clearly had administrative influence over the working of Z Limited. 26.3. Though it would have been natural for Z Limited to make fixed deposits in the normal course of its business, but in the given situation, writing of the LOC by entity number 1 for the amount of INR 200 crore on September 4th, 2018 with specific reference to Z Limited and correspondingly Z Limited creating the fixed deposit of exactly the same amount by the next date. In the given fact and circumstances on a preponderance of probability basis shows that the proximate cause of making the said fixed deposit was the LOC written by entity number 1. Please like the video, subscribe to the channel, share to your friends and relatives, as many people as possible, so that this type of frauds can be understood by individuals. If you read the full order by SEBI, you will understand how these companies are working. You can take cautious decision while you are investing in the equity shares of these types of companies. Thanks for watching.